Good day everyone, I am Ameline G. Madera, the first reporter of Chapter 3, the Dissolution and Winding Up of Partnership. We are done to Chapter 1 in which we talk about the general provisions of partnerships, kinds of partnership, creation of partnership, its elements, and etc. We were able to determine the obligations of partnership among the partners and to the creditors, it is from Chapter 2. And now, we are in the three final stages of partnership. We were all aware that partnerships were formed by binding up of two or more people who contributed their money, property, or industry with the intention of dividing the profits. In the scenario where Christian, Kuma, and Kaiden were best friends for 15 years and they were into music. Suddenly, they decided to build up a partnership in line with their interest. They named their business as Trio K Safe and Sounds Company and registered it to the Security and Exchange Commission. But what if one of the partners, example, Kaiden, decided to leave the business? What will happen to the partnership? After 10 years of handling and managing the business, even though successful yung business, Kaiden decided to leave the partnership because of too much stress sa long hours na ginugugol niya just to manage the operations well. In this case, the partnership must dissolve, wind up, and terminate. Dissolution, winding up, and termination are the three final stages of partnership. The dissolution, as per Article 1828, it is the change in the relation of the partners caused by any partner ceasing to be associated in the carrying on as distinguished from the winding up of the business. When any of the partner leave the business, the only thing that has changed is yung relationship niya sa co-partners niya and the partnership is dissolved but not yet terminated. Take note, if there is a change lang sa relationship ng partners, dissolve pa lang yung partnership, hindi terminated. Later on, malalaman natin kung ano ang pinagkaiba ng dissolution sa termination. So, as per Article 1829, the effect of dissolution is the partnership is not terminated, but continues until the winding up of partnership affairs is completed. Winding up process, it is yung mga sinisettle na yung business affair ng partnership. So, what are the reasons or causes of dissolution of partnership? There are several ways to dissolve the partnership, and with the uncertainty, maaring ma-dissolve yung partnership kahit na hindi desisyon ng isang partner umalis sa business. And these causes of dissolution will be discussed further by the latter reporter, particularly in the Article 1830, which is the causes of dissolution. Dito, i-discuss or i-categorize yung causes of dissolution. Sa akin, i-discuss ko lang yung several ways. So, dissolution happens when a partner retires, resigns, or withdraws. When a partner voluntarily give up his position or remove himself from business. It is his personal choice to end his participation. In the partnership. So, katulad ng example natin kanina, nag-resign na si Kaiden sa partnership. So, dito, dissolve pa lang yung partnership kasi may change na dun sa relationship ng among with the partners. When a partner dies, automatically the partner must dissolve if one of the partner is incapable na to do the operation or wala na siya totally. And when a partner expels another partner, dito, authorize yung partner na expel yung co-partners niya by anonymous decision. If he is in bad faith, or nilabag yung rules nila stipulated by the partnership contract, or if the expelled partner is insolvent, meaning wala ng capital na natira sa partnership because siguro, doon siya kumukuha ng pera sa contribution niya sa partnership. Or if it is stipulated in the contracts. Halimbawa, after 3 months, nag-agree silang lahat na tanggalin na sa partnership si Kaiden, and Kaiden also agreed and signed the contract. So, Kum and Christian are authorized to expel Kaiden after 3 months. So, another situation is when the expelled partner transfer or sell all of his partnership interest to another partner or to the third person. As long as they are all agreed to that decision, most importantly, yung decision o pagsang-ayon ni Kaiden or yung mawawalang aalis na partner, and then so be it, may change na dun sa relationship among the partners, dissolve yung partnership. What will happen after a partner retires, died, and expelled? Most of the cases, unless the partnership agreement provides otherwise, a partnership automatically dissolves upon retirement, death, or expulsion of a partner. Pero di naman need na i-end na yung partnership kasi dito may choice yung mga remaining partners na ipagpatuloy pa yung business. Or magkikreate sila ng new business, pero bago yon ibibigay muna nila yung particular shares na aalis or mawawalang partner. However, if they elect not to form a new partnership, the business will have to be wound up and terminated. Another causes of dissolution is declaration of bankruptcy of a partnership. When the business are no longer meets its financial obligations, that is the time na magde-declare na sila ng bankruptcy. If a general partnership is no longer able to meet its obligation, the partnership meeting must consider if the company is bankrupt. The partnership meeting should then apply for bankruptcy with the district court where the company is registered. The purpose of the proceedings is to get an overview of asset and turn this into money for distribution between the creditors. And after the bankruptcy proceedings and may unpaid debt pa din ng partnership, those debts will not be deleted after the bankruptcy proceedings have been concluded. As a partner, you are personally liable and responsible in full for all debt which has accrued. This means you will be liable for the component of the debt that is not repaid during the administration of the partnership. Another is agreement of partners. Dito, they mutually agree to dissolve the partnership, or as to the stipulation, partnership for particular undertaking or may specific goal sila na ma-accomplish. Halimbawa, after nilang ma-accomplish yung goal, such as makabenta na 1 million pieces of goods, this is the time na dissolve na yung partnership. Or partnership with the fixed term. Halimbawa, 3 years lang yung existence ng business nila. Last one, when a business is illegal. There are 2 ways that the business is considered illegal. First, if at the first place there is no legality on the operation at all, such as black market, smuggling, or selling illegal drugs. Second, when there is lawful operation in the business but becomes unlawful due to the declaration of government. Example, yung business sila Kuma, Kaiden, and Christian at 3OK Safe and Sounds Company is nagpaparenta sila ng video okay machines sa birthday parties and or any occasions. Legal pa yung business sila that time. However, marami daw namamatay dahil sa agawan ng kanta sa video okay. And dahil doon, nagkaroon ng batas na bawal na ang pagpaparenta ng video okay machines sa mga gatherings. This is the time that their business is in unlawful state. So for the sake na makuha nila yung shares nila sa partnership, dissolve, wind up, at terminate yung partnership. Kasi if we will remember, the effect of unlawful business is the contract is void at the first place. And the partnership is di na nag-exist sa mata ng batas. So the profit shall be confiscated in favor of the government. Kasi if hindi i-confiscate ng government, it would be immoral and unjust for the law and pinapermit din ulit nila na gumawa ng illegal yung partners kasi meron pa silang profits para gamitin ulit. So, as we will notice by the several causes of dissolution, we can say that dissolution occurs when there is a change in the number of partners. Nabawasan Kasi may nag-retired, may namatay, or may na-expelled na partner. Or pwede naman sa hindi inaasahang pangyayari such as bankruptcy of a partnership. So we are done to the first final stages of partnership. Let's now proceed to the winding up or the second final stages of partnership. As an Article 1829 states that, on dissolution, the partnership is not terminated, but continues until the winding up of partnership affairs is completed. Meaning, upon its dissolution, the partnership continues and its legal personality is retained. Typically, when a partnership is dissolved, the partnership business is wound up and terminated. Sa effect of dissolution, dito sa Article 1829, hindi dito na-allow yung any new business transactions. Pero yung mga existing contracts are pine-perform, such as collecting receivables, paying debts, and dito, sa process din na to, pwede silang makasuhan in case during winding up. So what is winding up? Winding up is a process of liquidating and distributing any remaining assets after dissolution. Dito, sa winding up, mayroong dalawang process which are liquidating and distributing. Sa liquidation, dito pina-perform or kinokolekta lahat ng receivables, binabayaran lahat ng outstanding obligations or yung unpaid obligations sa mga creditors, at nililiquidate or binebenta yung mga remaining assets para for the better distribution of share or profits among themselves. Pero paano naman yung utang ng partnership sa creditors? The issue of how to deal with debts is very important when a partnership business is terminated. A dissolving partnership will usually have two basic categories of unpaid debts. Una, sa outside creditors, and yung pangalawa, sa partners. Subject to any agreement to the contrary, the partnership debts must be paid in the following order. The first one is to the outside creditors, and second one is the partner who also creditor. The partners cannot change the rules that the outside creditors must be paid first para maprotektahan si outside creditors kasi the obligations of partnership sa kanila should be collected. So as discussed earlier, if after ma-liquidate ng remaining assets ng partnership and wala nang pakayanan o walang natira dun sa liquidation, the general partners must pay the creditors using their own funds, as it is already discussed in the chapter 2. As to liability of a partnership, a general partners can be held liable up to the extent of his separate capital, such as personal funds, cars, or even homes. The creditors may look after to the personal property of the general partners. If the partnership is limited, which is the creditors are not after dun sa personal capital nila, dapat aware yung creditors na limited partnership sila para hindi sila magabol or mag-file ng kaso. Next is distribution. Distribution is transferring of cash or property by a partnership to a partner with respect to their interest or shares in the partnership capital or income. There are methods that can be used in distributing shares among the partners. The first one could be stipulated in the partnership contracts. The distribution of their shares will depend on their agreement, and in the absence of stipulation, the distribution can be done by equal partition or equal ratio, arbitrary or any capital ratio, which is pwedeng 40%, 30%, 30%, ganun. Or depende sa capital contribution nila. It's either original capital ratio or ending capital ratio. So, ang proper way of distribution kapag ka nag-agree yung partners dito sa beginning capital ratio, the illustration would be, on January 1, 2020, merong initial capital contribution si Christian ng 50,000, si Kuma meron 60, si Kaiden meron 40, so merong total contribution or total beginning capital yung partnership ng 150,000 pesos. Yung shares ni Christian ay 33% came from his initial investment na 50K dinivide sa total initial capital ng partnership which is 150,000. Same process kay Kuma and Kaiden. Pero si Kuma merong 40% at si Kaiden naman merong 27%. And on December 31, 2020, if the income and summary of partnership is 220,000, the total capital of Christian ay meron siyang 116,000. Yung 50,000, inad siya dun sa 200,000 which is yung income and summary ng partnership times yung shares niya na 33%. Same procedures kay Kuma and Kaiden. Si Kuma meron namang total capital of 140,000. Si Kaiden naman merong 94,000. Ito yung procedures kapag ginamit yung beginning capital ratio sa method of distribution. Dito naman sa ending capital ratio, on December 31, 2020, merong end capital si Christian na 30,000, si Kuma merong 40,000, si Kaiden meron 30,000, and on December 31, 2020, the income summary of partnership is 100, merong share si Christian na 30%, 30K divided by 100K, kay Kuma naman 40%, kay Kaiden naman is meron 30%. Yung total capital ni Christian is 60,000. Inad yung 30K which is yung ending capital niya plus yung 100K times 30% o yung shares niya. Same din kay Kuma. Pero 80,000 yung capital yung magiging ending capital ni Kuma at 60 naman kay Kaiden. And if the partnership were finally settled, all the business affairs such as collecting, paying, liquidating, and distributing the shares among the partners, the partnership are no longer an ongoing concern. Meaning, wala nang ibang transactions pa na dapat i-operate or i-manage ang partnership because the partnership is legally ended. That would be all. Thank you for listening.